Very good morning, students. I hope you remember our last class over vested interest. In our last class, we discussed at length what do we mean by the term vested interest, and on the basis of the above reading, one can come to the conclusion that a vested interest is an immediate right to a property. In case of vested interest, the property which is transferred, the interest over that particular property is complete. The third one is the intermediate right. The immediate right may be either a right of a present enjoyment or a right of a future enjoyment. Next is on the completion transfer, the interest accrues to the transferee with an immediate effect and the transferee's title is complete. An interest is vested in a person unless a contrary intention appears under the following conditions. Now, on the basis of above, one can say that vested interest is an immediate interest, the title is complete, the enjoyment may be at present, may be of enjoyment to enjoyment to the property at present, or may be the enjoyment postponed for a future time. On the completion of the transfer, the interest which accrues in favor of the transferee takes effect immediately and the transferee's title is complete. Next is an interest which is vested in a person is a complete in itself. If suppose there is a contrary intention appears in the contract, then in that case the transfer is going to get the interest in that particular property according to the terms of the contract. But if it is not so, then in that case we would say that a transferee's interest in the property is a complete one. Next is the interest is vested under the following conditions. When we would say that the transferee get the interest is of vested in nature, when there is no time mentioned, second, where it is to take effect forthwith, and third, on the happening of the event. So students, when the interest is said to be a vested interest, when in the contract there is no time mentioned, when it is to take effect forthwith, that is to say, if it is mentioned that the transfer is going to get the interest in the property with an immediate effect. Next is if the transfer is going to get the property or the interest in the property with a on the happening of any particular event, then in that case that event, if suppose if of a must in nature, then in that case we would say the interest which the transfer is going to get is called as a vested interest. Next is where no time is mentioned. Now let us see one by one that when the interest would be termed to be a vested interest. First, when there is no time mentioned, a person gets a vested interest where where the term do not specify the time, when there is no time mentioned. Let's see an example. Naveen gets the vested interest from the day of the sale, though the possession may not be given to him immediately. नवीन जो है उसको vested interest उसी दिन मिल गया जिस दिन हमने सेल कंडक्ट किया, भले ही उसको पोजेशन हमने उस वक्त इमीडिएटली नहीं दिया होगा, बट द वेरी डे वी एंटर्ड इनटू अ सेल डीड, नवीन गेट्स अ वेस्टेड इंटरेस्ट इन दैट पर्टिकुलर प्रॉपर्टी. Next, where it is to take effect forthwith. Forthwith means what? Immediately, without any delay. So, vested interest will be created when the interest is specifically to take effect immediately without any delay. That is to say, we make a declaration that a person is going to get the benefit from this and this particular date. So that is to say, immediately without delay on that particular date, the person is going to get a interest over that particular property. For example, declaration given in the deed. Suppose if the deed says that from we are entering into a deed on 11th April, and we mention in the deed that on the 11th April itself the transfer is going to get interest over that particular property. So this would be where it is to take effect forthwith. Forthwith means what? Immediately. Next is on the happening of an event. If the vesting of interest is depend on the happening of a specified certain event, students, here I am saying that specified a certain event. A specified a certain event means what? the event which is of must in nature. So if the vesting of interest is depend upon the happening of a specified certain event, provided the event must be specified, explained, and must be certain to happen. What are the conditions? The event must be specified, the event must be explained, and must be of certain in nature, certain to happen. Then in that case, whenever the vesting of interest depends upon the happening of an event which is of must in nature, and if that event is specifically mentioned in the contract, explained in the contract, and is of simultaneously certain in nature, then in that case it is called as a vested interest. For example, death of a person is certain, coming year is certain, coming date is certain, etc. Now, on the happening of an event, when we say that a transferee would get a interest over that particular property on the happening of that event. Now, on the happening of an event means on the happening of that particular event. Suppose if the vesting of interest is depends upon any happening of any particular event, and if that particular event happens, then in that case the transfer is going to get interest in that particular property. So on the happening of the event inclusive of the enjoyment, if the happening of that event, suppose if that event is going to take place in future, but enjoyment is postponed, but as far as the interest in that particular property is complete. Next is a prior interest, because the vested is complete, but the person is going to get an enjoyment afterward. So till the time he becomes a mature, in order to take the enjoyment of that particular property, a prior interest may be created, as we have seen that by virtue of section 13, one can transfer the property for the benefit of an unborn person. But because unborn person is not yet even conceived in the mother's womb, what has happened is, where whatever the property we have transferred, he is not in a position to enjoy that particular property, because he is not in existence at present. He is not in existence even in the mother's womb. He is not yet conceived also. Then in that case, we even in that situation can transfer a property in favor of a transferee, but provided we have to create a prior interest. So suppose even if a case, or even if a situation wherein a prior interest has been created, who the and these prior interests would be taking care of this particular property till the person who is ultimate beneficiary of that particular transfer comes in existence. Even in this situation, we would say that the interest which is transferred is a vested interest. Next is accumulation of income. Students, while dealing with section 17 of the transfer of property, we dealt with we dealt with such a kind of a transfer wherein a direction has been issued by the transferor to the transferee, that though he is transferring a property in favor of a transferee, but transferee have to accumulate the income, and he have to accumulate the income for a particular time period, or till the time the transferor is there. Then in that case, such type of a transfer would not be termed to be a void one. That is to say, even if the direction has been accompanied with the transfer, wherein the direction for accumulation of the income has been provided, then in that case also, whatever the property which is vested in a transferee would be termed to be a vested interest, or a vested interest in that particular property, even though that vested interest, or even though that particular transfer is accompanied with the direction for accumulation of the income. Next is the conditional limitation. Conditional limitation means what? Suppose if any kind of conditional limitation is there, then in that case also, but if that particular transaction or the transfer of the property is accompanied on the happening of an event, and if that particular event happens, then in that case that particular transfer is going to get a vested interest in that particular property. The vested interest is at the very day of entering into that particular contract itself. Transferee gets that vested interest in that particular property, but the only thing is the conditional limitation may be there in one or the other form. Next is, let us see what do we mean by the term enjoyment is postponed. Now, Sevadayal versus official trustee. In this case, it was held by the court that if there is a transfer of interest wherein the enjoyment of the property is postponed, still it be termed to be a vested interest. Next is a condition postponing the enjoyment does not prevent the interest vesting immediately, but it is itself a void for repugnancy after the transferee has attained majority. That is to say, if suppose while transferring a property in favor of any person, we thereby postpone the enjoyment of that particular property by this particular transferee for a certain period, then in that case it doesn't mean that a person is not having a vested interest in that particular property. In fact, the transferee would be having a vesting interest or vested interest in that particular property. Only the enjoyment of that particular property is postponed for a certain time. But as we said, it is only up to a certain time. That is to say, maybe till the life of the transferor or maybe till the minority of this ultimate transferee. So, the very moment the transferee attains the majority, he would be having a right to enjoyment of that particular property. But suppose if any of the condition restricts or prevent him from enjoying of that particular property even after attaining the majority, then in that case such type of a direction would be termed to be a void one. So that is to say, a condition postponing enjoyment does not prevent the interest vesting immediately, but it is itself void for repugnancy after the transfer has attended after the transferee has attended majority. Next is repugnancy. What do we mean by the term repugnancy? Repugnancy means an inconsistency. Now let us see example. Namrata transfers a property to Rajasi in trust for Vaishnavi and directs Rajasi to give possession of the property to Vaishnavi when she attains the age of 22. Rajasi has a vested interest and is entitled to the possession at the age of 18 years. For the reason 18 years is a age wherein the person becomes competent to enter into a contract, and therefore the interest of the Rajasi would be termed to be a vested interest at the age of the 18 itself. She don't have to wait for further 4 years for enjoying that particular property. Next is prior interest. If while transferring a property, a prior interest in the same property is given or reserved for some other person, it does not mean that it is not a vested interest. If there is a creation of the prior interest, there is only a postponement of the enjoyment and not the vesting of subsequent interest. So, creation of the prior interest does not restrict the vested interest or does not affect the vested interest. There is simply a postponement in the postponement of the enjoyment, and that too postponement of the enjoyment is only for a limited period only. Next is, for example, let us see an example. If Sanjana transfers a property to Sharda for a life and then to Udit, here the transfer of Udit is a vested interest, but only due to the creation of the prior interest in the property in favor of Sharda. Udit's right to enjoyment is postponed till the life of Sharda. So, this is an example where the prior interest was created. Now, come to next, that is accumulation of income. While transferring the particular property, if a direction is issued relating to accumulation of income of that particular property, it does not mean that the interest transferred is not a vested interest. Provided the direction is given to accumulate the income must be within the sanctioned limit provided in the section 17. If the limit exceeds the direction, would be termed to be a void one. Only the right of enjoyment is postponed, but not the vesting of interest. Here it is mentioned that if a direction of accumulating of income is associated with the transfer of property, then in that situation also whatever the interest which is transferred in favor of a transferee would be termed to be a vested interest, for the reason that direction for accumulation of income is only for a specified time period. If we go beyond that particular permitted time period, then in that case, that particular direction would be termed to be a void one. So till the time the direction for accumulation of income is within that particular time limit, permissible time limit, then in that case we would say there is only a postponement of the enjoyment and uh, not the postponement of vesting of interest. In fact, it is already the vesting of interest. The transfer is already having a vesting of interest. But the only thing is he have to accumulate the income for a particular time period as the directions which are issued by the transferor. Now next is conditional limitation. Now what is conditional limitation? So if a condition is imposed that if a particular event shall happen, the interest shall pass to another person, such a person is called as a conditional limitation. Now such condition devasts an estate which has become vested and waste it in the another person. Now student, this is very important. Here the vesting of interest has been once created, but again that particular vesting of interest moves to some another person because of the conditional limitation or because of the particular event. If it takes place, then in that case the interest shall pass from one person to the another. Which interest shall pass from one person to the another? The vesting interest or vested interest would pass from one person to the another person. Now let us see the example and we'll try to understand it. While transferring a property, it is mentioned that A should have an estate for life and that after his death B was to be the full owner of the estate. If he survived A, this is the condition. If he survived A. If B did not survive A, the estate would pass to B's lineal male descendant according to the rule of primogeniture. Before the death of A, before the death of A. Now the question arose whether the B has already a contingent interest or a vested interest. Now B has already a contingent interest or a vested interest. Solution is if the provision has been merely this that the estate would pass to B would take the estate contingent on his surviving A. The further provision of the gift over to another person was a conditional limitation which had the effect of vesting the estate in B. The court gave the reasoning that the condition affected the retention of the interest and not in its acquisition. Therefore, B took a vested interest liable to be devastated if he did not survive A. Reason the condition affects the retention of the interest the it is and not its acquisition. Therefore, B took a vested interest liable to be devastated if he did not survive A. Now, important points which need to be kept in mind is a time of vesting as soon as the transfer is complete. Second is contrary intention. Time of vesting interest may not be beyond the period allowed by the rule against perpetuity. And third one is the death of transferee. That is to say, when an interest is vested, it becomes the property of the transferee and he can transfer it even before he has obtained the possession. A transfer of property even without possession is effective if the transferee dies. His interest vested in his legal representative whether or not he has obtained the possession. Now next is characteristics of a vested interest. Vested interest does not depend upon the fulfillment of a condition. It creates a present and immediate right, but the enjoyment may be postponed to a future date. Next is a vested interest is transferable as well as heritable. A vested interest is not defeated by the death of the transferee before obtaining the possession. The interest pass on to the heir of the transferee. That is to say, a vested interest is not defeated by the death of the transferee before obtaining a possession. If suppose a vesting of interest has already been created, then in that case the interest passes on the heir of the transferee and the heirs would be having a right over that particular transfer. Now let us see the vested interest in case of minor, which has been provided under section 20. An interest created in favor of an unborn person vests as soon as he is born. Next is the possession may be postponed, but the transfer is vested in him when he is born alive. Example, Udit settled his property on himself and his intended wife for their joint life and later on to their eldest son of marriage. तो son जो है takes the vested interest as soon as he is born, but he is not entitled to the possession during the lifetime of his parents. Now this section contemplates the normal condition in which the unborn person is born alive. But suppose for example के तौर पे if unborn person dies within the womb itself in his mother's womb and is not alive, then in that case definitely this section would not apply, right? Next is we have here completed the vesting of interest. In our next session we'll be dealing with section 21, that is contingent interest under transfer of property act part 2, and we'll be further dealing with the difference between the vested interest and contingent interest. Thank you students for thank you for attending this session. Thank you.